permission or other authorizations required by law in any jurisdiction. All right. So that is a very tall order. So the proposed representative, right, whether it's appointed, provisional or temporary, has to declare that over the last 10 years, all right, A does not apply to me. Right? You have to declare that. And similarly, B, prohibition order, and C, whether it's been disciplined, suspended, right, and so forth. It's similar to what we have looked at earlier. And if you cast the eye down the page, there is a long list up to Q, right? So therefore, there's a checklist there, and usually the financial institution will put all that down. And on the right-hand side, they have a column, a box, ask you to check the boxes. All right, so the answer is yes, no, then no is fine. If yes, then again subject to the assessment and the judgment of the financial institution whether to hire you or not as a representative, right? So there's a long list there, right? So I'm not going to go into the details, so you just cast your eye down the page. It is similar to what we have discussed, right? All right, I'm not sure whether you have seen this, but I've done a couple of these myself where I check no all the way, because the details set out in that particular honesty, integrity, reputation, all the items there do not apply to me, so you check no, right? All right, it's within the past 10 years. Okay, so I'll leave you with that one. Now, if you were to take a look at paragraph 7.1a to Q, you will notice that some of these are all quite serious offences, right? So it relates to a person's honesty, reputation, and integrity, right? I'm a bit concerned with some of the items there, though. Suppose you look at paragraph N, right, has been dismissed or asked to resign from office, employment, of a position, and so forth. All right. So sometimes when you are asked to resign from office or employment, it could be due to other reasons other than honesty or integrity or reputation. Right? Anyway, whatever it is, it relates to honesty and integrity. Right? So that's that. Now then, look at financial soundness down the page there. All right. So financial soundness, again, it is the same thing. It says within the past 10 years. Right? Whether the individual has under A all the way to E. Okay, so they're looking at a 10-year time frame in terms of financial soundness, in terms of honesty, integrity, and reputation. Now, in terms of competency and the capability, which is the second component of the fit and proper criteria, the details are not given, but you will notice that they refer to the continuous training of the representative once this person has come on board, all right? And the CPD hours generally will take that into consideration, into account, okay? That's why there's a requirement for CPD hours, all right, to ensure competency and capability. So ongoing, continuing training is a necessity. Now that covers the Annex 1. All right, now quickly let's look at Annex 2. All right, and paragraph, the heading reads, due diligence checks to be conducted by the financial institution. All right, so due diligence checks to be conducted by financial institution. All right, so the first part refers to the declaration and details of self-declaration, right, fit and proper declaration. And now this second part talks about the due diligence checks to be conducted by the FI. All right, so paragraph 1 there at 4.31 and Annex 2 talks about the onus is on each relevant person to establish that that person is a fit and proper person. Right? I've explained this to you earlier. The onus is on that person and not on the MAS, right? To discover or to show or to prove that that person is not fit and proper, right? So in other words, the ball is in the court of the representative or on the financial institution. And then quickly look at 2 probity checks on the representative's identity. So when a financial institution submits a notification to appoint a particular person under the RNF, right, the framework that we talked earlier, it is required to provide the proposed representatives A, National Registration Identity Card number. Right? This is NRIC. Right? So that must be submitted. This is a unique number, or the foreign identification number. Right? If that person is a foreigner with no IC, with no National Registration Identity Card. So this is a FIN, foreign identification number. And this generally must be a unique number, okay, rather than a passport number, okay? Because a passport number in some jurisdictions, in some countries, they do change over time, right? Right. So, you require a unique identification number, or passport number if it's a provisional representative or temporary representative who has neither an NRIC nor a FIN. All right. As a last resort, if the person is a foreigner, then no IC, no FIN, then passport. Right. Right. Now, prior to submitting to the notification under the RNF regime, the FI is expected to obtain a copy of the proposed representative's current identity documentation, right? Underline the word current, unique identity documentation. So there is evidence to show that you, the financial advisor or the financial institution, has verified this person's identity. All right? So if the proposed representative is a foreigner, the FI is expected to verify that he has a relevant employment pass, whatever level employment pass, or has sought approval from the relevant authorities to work in Singapore. Right? So whichever the governing regulatory authority is, right, you must get the approval for this person to work in Singapore. Okay. Now, if you look at the footnote 3 below, you can see there a further requirement. The financial institution is required to notify the MAS of any change in a representative's particulars within 14 days of the change. All right, so that the relevant authority, and in this particular case, relating to financial advisory services or banking services or related services, under the purview and the regulatory authority of the MAS, then the financial institution is required to use Form 16 of the SFA, Licensing and Conduct of Business Regulations, under Regulation 10, on Form 1818 of the Financial Advisors Regulation, Reg 2. Alright, this includes changes to the representative's identification particulars, passport numbers, identification numbers. Like I said, passport numbers do change. All right. So if the foreign person, a foreigner, changes his passport or her passport, then that must be notified to the MAS of such change. All right. And any other particulars such as changes in residential address or the particulars of the representative's spouse. All right. Now, why is that important in terms of the changes in the representative's spouse? All right. Now, supposing a person comes in and he's not married. Now he's married, right? So the reason why you need the spouse is in relation to whether this spouse is a PEP, all right, or related to a PEP. You know, it's a PEP, right? It's a politically exposed person, all right. And being a wife, well, the husband is a close associate of the wife, all right. So it is family, all right. So when you are family, as defined in the in the notice on politically exposed person, in terms of the customer due diligence or enhanced customer due diligence, then you need to know. Or if the representative should divorce his current wife and then marry a new wife, and the new wife is a PP, and then the authorities must be informed accordingly, right? So you need particulars of the representative spouse, etc. Right? So the etc. is quite worthy to note. So if any other reasons, any other particulars that are changed, and the financial institution find that this change in particulars is significant, or if the change is important enough, then you need to report to the MAS. All right. Right. Now let's move on a little bit more on this. So that's in relation to the probity checks on the representative's identity. All right. So the financial institution has this role and this function and this duty to discharge. All right. to do probity checks on the representative's identity, right? Make sure you have the correct person working with you or for you, right? Now, insofar as the financial institution is concerned, again, the next segment talks about probity checks on representatives' past records. All right. So first, you check that representative identity. Now you look at the past records. All right. So paragraph 4 is quite clear under 4A, B, C. So what are you expected to check? All right. So the financial institution is expected to check all these things, right? Conduct reference checks with proposed representatives' previous employers. Right? So previous employer check. And look at footnote 4 below. It gives you more details there. Right? I'll come down to the footnote or subscript 4 later on. To confirm that he has not been dismissed or asked to resign, and to ask if there's any material adverse record. Right? Any warning, reprimand, any demotion, or any fine or whatever for misconduct taken by the previous employer or employers. All right. So the duty is fairly onerous, so the FI must check. All right. Now cast your eye down to the footnote 4 below. It says the FI should conduct reference checks with relevant departments of the individual's past employers, human resource department, personnel department. All right. When conducting such checks, the FI should provide the individual's previous employers with his NIC number to ensure that the individual's record can be properly traced by the previous employers, even if the individual uses underline a different name in his employment with the current employer. Right? So they are very meticulous, very detailed. All right. So a proposed employee for this hiring a financial institution must therefore do a check with a past employer. All right. Now, if this proposed representative uses a different name, all right, then it may be difficult to check. So here, the requirement or the guideline to you, when I say you in this case, it means the financial institution or people doing work on behalf of the financial institution. You ought to give the NIC number. All right. As I say, the NIC number is a unique number, all right, or a FIN number. All right. A FIN number is a foreign identification number, which is unique, all right? So that it is easier and it is more accurate to trace this particular person, all right? Unique numbers, easier to trace and check. Name, a bit different, right? They use different names and aliases and so forth. All right, so that is the expectation of the financial institution, all right, to check whether the person you intend to hire, right, has been dismissed, asked to resign, etc., any misconduct. Right, so that's one. Now under 4B, which is 2, the FI is expected to check the public register of representatives on the MAS website. To verify, circle the word verify, so the issue is verification, the proposed representative's past employment records as the appointed provisional or temporary representative in Singapore. All right, as you know, in the earlier chapters, where we talk about this putting on record the particulars of the representatives in the public register, the employment records should also be there. All right, so therefore, if you check the public register on the MAS website, the FI may be able to verify any past disciplinary action or regulatory action taken against this particular person, right, including a prohibition order. Okay, so that's B. And C, conduct probity searches, including but not limited to publicly available registers provided by enforcement and regulatory agencies, right, like FATF and the UNSRA and so forth, right? Self-regulatory organizations and even professional body or association, all right, in order to verify, keyword verify, the proposed representative's criminal or disciplinary records under any law, any rule in any jurisdiction, right? Past records of regulatory status and employment records. So the details are all given to you, what to check, what details to check, right, in terms of this person's past records, right? So that's under 4A, B, and C, right? So that's important, and I spend a little bit more time on it, right? And of course, paragraph 5 says that under the SFA, section 101B, and under the FAA, section 60, is an offence to employ any person who has been issued PPO by the MAS when the PPO is still in effect, right? And of course, the FI should ask the proposed representative to give any reason for any period of time when he's unemployed, right? So there could be times where the proposed representative should decide to take a sabbatical, right? He did not resign. He was not asked to resign. He was not asked to resign, or he was not dismissed. All right, but he decided to take a break and take a 2-year sabbatical. All right, and therefore within that during that 2 years, he's not employed at all. All right, that is being the information is being furnished by the proposed representative to the financial institution. All right, so during that 2 or 3 year period when that proposed representative is on sabbatical leave, then reasons must be given, and then the financial institution should document these reasons accordingly. All right. In fact, I've come across a couple of people whom I know when I was in London. All right, and these people just take 2 years off. All right, and these people are essentially the fund managers. Right, they are a very stressful job. Right, so they make some money, they make a lot of money. They do fixed income products, and they do funds. So very high level stress, and they make some money. Then they decided to say, okay, I take a 2 year sabbatical to recuperate, as it were, and then therefore during the 2 years they are unemployed. All right. So when they come back to the market, so the financial institution or this person has to tell the financial institution, I'm out of job for 2 years, 3 years, right? And I'm on sabbatical, and reasons are given. And the financial institution should therefore document the reason, right, that this particular person is on sabbatical. And of course, the financial institution should not take this person's word for granted, right? So maybe the financial institution should then do a reference check with the last employer and find out whether this person really has taken a sabbatical or from that particular company. So those are the verification exercises that the financial institution should conduct under this particular circular. Okay, so we have done that so far. So identity checks, then you got past records checks. Now let's move down quickly on the financial status checks. So look at paragraph 8. All right, paragraph 8 talks about the financial advisor to make sure that the proposed representative is not a subject of a bankruptcy petition or a debt repayment scheme. Now, debt repayment scheme simply means that this person owes people money, right? Credit card companies and so on, or a bank, owes bank some money, or a credit card company some money, and therefore you are in debt. And in which case, you have the debt repayment scheme with a bank or with a credit card company. Right, so if that is the case, then the financial status is question mark. Right, it is a question mark. Or worse, it has been declared and remain a bankrupt, whether in Singapore or in some other jurisdictions. Okay, so at the minimum, right, the financial institution should obtain the proposed representative's record from the Insolvency and Public Trustee's office. Right, so it is relatively easy to check whether a person is bankrupt or not. All right, and as a lawyer, I do that quite a lot. All right, if my client should decide to sue a particular person, the first thing I check is I look at this particular website, all right, the Ministry of Law's Insolvency and Public Trustees Office website, to see whether this particular person is a bankrupt or not. All right, so if this particular person is a bankrupt, there's no point suing that person anymore. All right, well, generally that is the position, unless there are other reasons. And even if I were to start an action on behalf of my client to sue a bankrupt person, well, I have to get the official assignee's permission to do so, right? So Similarly, if you want to sue a company, all right, you need to do a winding up search to see whether this company is in the process of being wound up, or under receivership, or under judicial management, or under such other forms of liquidation. Because it's no point to sue a company that's in the process of being wound up, and of course you cannot do so because all proceedings are suspended, put on hold until the company has resolved its status. So in any event, just to move on, so at the minimum, the financial institution should check with the Insolvency and Public Trustee's Office to establish or to check whether the proposed representative was a bankrupt or not. And if the proposed representative tells you that he was self-employed previously before he makes the application to join the financial institution, then the financial institution, or the principal as is written there, should obtain the individual's records from the CPF board to verify that it's not in arrears of his contributions to the CPF board as required under the CPF Act. Alright? And then the FI should conduct with credit agencies, alright, including bankruptcy status in overseas jurisdictions where possible. Alright, if the applicant for the job of a representative is a foreigner, okay, and the FI should consider requesting these proposed representatives to conduct a search of his own credit status with the credit bureau in Singapore and forward the result of the search to it. Right, so this is in relation to the probity checks, right, to the probity checks on the on the representative's financial status. All right, so those are the three key things that the financial institution has to check, right? Right. So if you look back at Annex 2, the heading there, these are the due diligence checks to be conducted by the financial institution, right? So there are three in total: probity checks on representative's identity, probity checks on the representative's past records, and probity checks on the financial status, right? Now you'll notice that all this relate back to the fit and proper criteria. Alright. Okay, now let's move on very quickly. Alright. Now of course paragraph 10 to 12 talks about the false or misleading document or information. Alright. So again, I do not wish to go further into this. All right, because as a proposed financial advisor representative, as a proposed employee, there is a requirement for that particular person to provide truthful information and truthful declaration, right? All right, and once this information has been declared to you, the financial advisor will do the investigation, do the probity checks, and to ensure that the two matches, right? The self-declaration, the information given by the rep, and your own on the financial institution's own probity checks. All right. So if the information does contradict, then there could be problem as to the false declaration by the proposed financial advisor representative. Okay. And of course, the financial institution or the financial advisor must point out to the proposed representative regarding the consequences of any misleading or false declaration, right? And the financial penalties that attaches to it, right? And paragraph 12, very quickly you can see, MAS will not hesitate to take regulatory action against any individual, any natural person for omissions or for misrepresentations in relation to the declaration regarding fit and proper criteria. Or for that matter, the MAS will take action against a financial institution, all right, for not conducting the reasonable due diligence checks as provided or as guided in this particular circular. All right. So the probity checks are important: identity, past record, and financial status. So these three must be checked by the financial advisor or the financial institution, as the case may be. You look at 12A, all right. So 12A talks about a principal okay, making a false or misleading statement in a material particular, or omitting from any document lodged with the MAS any information, rendering the document misleading in any material aspect. All right, and be the individual, right? So again, they provide you with a warning there. So it is an offense under section 990 of the SFA and under section 23L of the FAA. I think this one we have talked about earlier. Now let's move on. Now the last point in this particular circular is paragraph 13. All right, here it refers to periodic declarations and checks. So on the one hand, we have the self-declaration, the details are there. But on the other hand, the financial institution or the financial advisor, all right, they are required to do the probity checks. Now, having said all that, the circular now provides under the last segment here, the periodic declarations and checks. All right, so I just read to you very quickly this part. The principal should obtain on a periodic basis, for example, annual